Hi all, Midun back with a new video. This is a second session of our contract practice video, which it's going to be useful for those people who is preparing for RICS interview or APC candidate or someone who wish to learn more about contracts. And last session we have done a detailed video on contracts and agreements which explain all about contracts. Okay, so let's move forward. So in this session, I'm going to explain something more about other than contracts. So you can see over here, LOA, all these things I'm going to explain. So starting with LOA, letter of acceptance. This is, you might have come across this term in your professional life for sure. So basically, letter of acceptance is the formal acceptance of the contract. You know, this is the formal letter of acceptance of contract. This is the definition of LOA. So you submit the offer, it's been accepted by the party, and now you are formalizing the offer through a LOA, which is called letter of acceptance. Please keep in mind, in LOA it's supposed to have all the ingredient of the contract. It should have an offer, it should have an acceptance, it should have a consideration, then all possibility of performance, capacity, certainty of terms, everything should be part of LOA. Okay. LOA, sometimes LOA issue as a full set of contract. I'll tell you how. Even you call it as a LOA, you will include all the contracts and the documents under LOA. And sometimes you issue an LOA as a 32 sheet paper also, in which you will write this LOA is the agreement between party A, party 2 for scope of work, and this is the amount agreed, and this is based on the tender issued on this date, and tender addendum issued on this date, PTC on this date, negotiation on this date, BAF on this date, LAF on this date. So it means it become implied. Okay, the party, when you sign, it's supposed to have the full knowledge of all these items listed. So two type we will issue LOA. One is very simply 2 or 3 pages in which you write contractor name, employer name, scope, and how much is the amount, and what base was the LOA, like tender, at this reference, PTC, TE, all those things. In other hand, you can also issue LOA by including all these documents. You will include this specification in BOQ, some full set of drawings, sometime list of drawings, exception, exclusion, PA, TQ, PTC, everything can be included. Okay, so that is the formal letter. LOA is a contractually or legally binding document. Why? Because it has all the ingredient of a contract, that it has an offer, it has an acceptance, it's a consideration, it has a legality, it has a validity, it's possible to perform, capacity of party is there, everything is there. So it's called a legally binding document. Okay, so now I'm moving to LOI, letter of intention. LOI, so LOI is basically issued on event. So you have an intention to issue a contract to a contractor in a future date. Now you are not telling him that this is an agreement between you and me. You are telling, dear contractor, I have an intention to issue a contract to you on this date for this scope of work. Okay. Now you may proceed with this small scope of work. Okay. Let me give you one more example. You have a what do you call that, you have a construction of a high-rise building. Okay, and you have an intention to give it to a one contractor through a single source tendering. You approach only one contractor and you have wished to give, issue the contract to him, but still you have not get any permit and other documents. You're waiting for permits, municipality documents, and all those permitting authority documents from the municipality or AHA. But still you want this contractor to start some initial work, like you want him to work on some drawings, you want him to work on some long lead items, or you want him to work on a program. In this case, what you do is issue a LOI. It's not an acceptance or a contract, just an expressing your intention to have a contract with him in a later stage. Very important thing, and where you have to keep in mind, LOI is not a legally binding document. Why? Because if it has to be legally binding, it should have an offer, it should have an acceptance, it should have a consideration, and all other ingredients which will form a valid contract. But in LOI, we will issue only an intention to enter into a contract in a later stage. So that is the difference between LOI and LOA. Hope it's clear, because LOA, the first thing is that it's legally binding and it has all the ingredients of the contract. LOI does not have all the ingredients. Okay. Letter of award. So letter of acceptance, LOI. What is this letter of award? Letter of award is basically a standalone document. It's not referred to any other document. Okay. In the previous case, when I explained LOA, I mentioned this LOA is based on tender issued on this date, PTC issued on this date, tender addendum issued on this date, all reference will be mentioned. Okay, but in this letter of award there is no reference. It's a standalone document. Okay, the contract is awarded to this contractor by this employer to carry out this scope of work for this amount of money. That's it. That's the letter of award. Okay. Then letter of comfort. Letter of comfort is basically issue you to give, just as name indicate, give a comfort to the other party, whoever be in the opposite side, be it a consultant, be it a contractor, whoever. I will give an example how or when it should be issued. Imagine you are a main contractor and you bidding for something, and you obtain a price from a subcontractor, be it a MEP subcontractor. Okay, the tendering process is going on. Okay, you use his rate, you put his OHP and submitted your tender. Okay, but for some unforeseeable reason, the tendering process is extended, or you yet to receive a clarification, but you know that you're going to get the project because you are the final shortlisted, and employer kind of confirm like you will be the one we going to award, but still we waiting for some money from the bank. So now what you have to do, you have to block your MEP contractor, or else he will find other job. Okay, because there will be 100 tenders to him, he will be receiving 100 inquiries. To block him, what you do, dear MEP contractor, you almost onboarded, and you will be, this is to make you comfort that you will be getting the contract from our end, subject to, or I'm waiting contract from the employer, and employer confirm me I'll be getting. So this is to comfort you that I will be getting, or you will be working with me for sure. So basically you're giving a comfort to him just to ensure that he will be part of it, or block him, you can tell like that. Sometimes employer also issue this letter, because he might be waiting for a bank loan, or sometimes he will be waiting for a launching ceremony, something like that. Okay, now what is bespoke form of contract? Guys, the form of contract is mainly two types, I can tell you: standard form of contract and bespoke form of contract. So standard form of contract is something which is based on FIDIC, NEC, JCT, because it's already prepared, it's already time tested, it's ready to use actually. So a standard form of contract is something like a body, be it a FIDIC, be it a NEC, be it a JCT, be it RICS, MCIOB, whoever. Some body like that prepared a forms of contract. They prepared general condition, and you can ready to use that. You can just pay some money or take a membership and you can use the forms of contract. It will have some, all general condition will be there. That is called standard forms of contract. In GCC and Middle East, we mainly use FIDIC form of contract, but other region like UK or US, mainly UK, they'll use JCT, NEC, other form of contract, which I never use honestly, JCT or NEC. I mainly use FIDIC form of contract. What is the benefit of having the standard forms of contract is that, guys, it's readily, first thing is that it's ready to use. You just need to pay some money to FIDIC, get that membership or something like that, then you can readily use. You don't need to go through one by one because it's already time tested, It's already known to all the parties. It's known to contractor, and it's known to employer, it's known to consultant. And secondly, there will be balanced allocation of risk, responsibility, and obligation. Okay, and mainly when you use a FIDIC form of contract, contractor know completely about the contract or form of contract. He know the general conditions, so he will not load his risk on it. I will give you an example. In FIDIC form of contract, the payment, for example, clause number 14, where you can see payment cycle and all. So as per the FIDIC, within 28 days, you have to get a certificate. As a contractor, will get a certificate, and within 28 days, like that is within 56 days, you will get a payment. This is, it's not to everybody. It's not to contractor. It's not to consultant. What if you changing this? You changing, instead of 28, you making it 56 days certificate. Instead of 56 days payment, you will make it 80 days payment. So that's a risk actually. You change the payment term now. So standard form of contract you modified. So definitely if a contractor look into it, that only after 80 days he will get the payment. So he has to fund, or he has to pay his employees for this 80 days without payment. So he going to load this risk into your contract. So there is chance like you may get highly accelerated bids. Okay. This amended form of contract is called bespoke form of contract. It's not based on any standard forms of contract. This is called bespoke form of contract. Sometimes you will have general condition FIDIC, then you will change everything in that condition, and it's bit called as a bespoke form of contract. Even if you change a single clause in the general condition of any standard form of contract, it's called a bespoke contract. Okay, what usually people do or employer will do is, whichever clause against him, that he will change, whichever clause against contractor, that he will make it more strong. Okay, like employer claims 2.5, delay in insertion of drawings. So there are clauses he will put some 30 days extra, 15 days extra. Notice of claim he will make within 6 days, contractor to give the notice. And suspension clauses, then termination clauses he will change. And for possession of site, that he will change. So usually what employer do is like something favorable, he will try to make the clauses such a way that he will make it favorable to his benefit. Obviously contractor is going to load his risk on that for sure. And sometimes he will change the litigation, then law, he will change the arbitration requirement. So all those things he will change. This is called bespoke form of contract. So to conclude, standard form of contract readily available, prepared by some reputed body. You can immediately use it. It's time tested. There's no risk. All party know about the risk. There is a balanced allocation of responsibility, roles, everything. Bespoke is, but whereas bespoke is something which is not related to any standard forms like FIDIC, JCT or NEC. It's not time tested. There could be under legal issue under there could be 100 risk will be there, and people will risk a lot of because they might not be familiar, so they will load the risk of that familiarity, load the risk of deviation, everything will be there. Okay, I hope LOA, LOI, letter of award, letter of comfort, bespoke and standard is clear to you. Moving forward, so now guys, just let me tell you, these all are part of contract practice, which is for the RICS interview. You can call it as level 1, level 2, because I'm explaining the concept also. So you will be able to explain some question based on a level 2 also. For example, if assessor is asking you, will you prefer an LOI or LOI to a contractor, and why? Because then you can tell them like, obviously I will go ahead with the LOA. Why? It has a legal validity. And LOI, no. Why? It's not has a legal validity. However, depends on requirement, I may consider like that. Okay, now moving forward, I'm going to explain priority of documents. So this is a common term you might have heard. Priority of documents basically, it's mainly to ensure, if there is an event of discrepancy, disconfirmation, clarity requirement. So what is the precedence of document? Which document should stay above all document? This is called priority of documents. Okay. In your family, you have father, mother, son, daughter, everybody. So who is the top? Your father. Just like then mother, then your daughter. That priority is there. No, who had the best priority? Similarly, when in the family, when there is a confusion or a conflict, father will take the lead and tell follow this. And similarly, priority of documents in a contract, there is a list of documents which have top priority compared to others. This is mainly when there is a conflict, dispute, or a clarification requirement, we will follow this priority. Again, one more thing, let me tell you, even there is this priority of documents, it's clearly mentioned in the FIDIF that these documents expect to be mutually explanatory. So these documents define the full contract. Okay, and contract supposed to have the precedence. Let me tell you an example. In the drawing, there is a lift. It's a very high level example, and you may sound funny also. In the drawing, there is a lift. Okay, but in specification there is no lift, or there is no specification of lift. Then you cannot tell specification has higher priority, so we haven't considered the lift. It's common sense, in drawing there is a high-rise building, lift is there, it has to be considered. You can't tell them like there is no specification of the lift, so this is excluded from our scope. This is just a high-level example to tell you the essence of this priority of documents. It does not mean that if something is not in the any of this document, it shouldn't be considered. It should be considered mutually explanatory basis, just like how I explained for the lift example. If something in specification but is required, doesn't mean that it's not excluded or it's not part of scope. Okay, so priority documents as per FIDIC 1987, 1999. 1999 I will explain first. So in 1999, contract agreement, letter of acceptance, letter of tender, specifications, drawings, then any other schedules or other documents. Whereas in 87, you have a contract agreement for sure, letter of acceptance, the tender, then part 2 of this condition, part 1 of this condition, then any other documents. I think I made a mistake while explaining 99. In 99, there is contract, letter of acceptance, letter of tender, particular condition, general condition, then specification, then drawings, then schedules. Because I think I missed this conditions, like particular condition and general condition while explaining. Okay, so this is the priority of documents. You have to consider if there is a ambiguity or discrimination. Based on this, engineer will give a determination. Okay, so priority document, I think the concept is clear. Now you would be or should be able to answer a level 2 question. Next, which all clauses will amend while preparing a bespoke? I think I explained already which all clauses. Sometimes I have seen people changing all the 20 clauses in the contract also, because they will change something. You put some, delete some wordings, add some wordings. But however, something, mainly payment terms they will change, variation clauses they will change, employer claim clause number 2.5 they will change, and then contractors claim clause number 20 they will change, and sometimes clause number 4 they will change, make some modification, and in the clause number 1, then clause number 2 in which there is employer responsibility is mentioned, that will change. Then if you go to termination clauses, they will change a couple of things, which there is some provision to terminate the contract by contractor. That clauses they may be modified. They will change the DAP methods, they will change the laws, all those things. You just go through the clauses from 1 to 20, and in your contract you can see majority of clauses might have changed or amended in your benefit, or something like that. Okay, so when somebody asks you which all clauses will amend while preparing bespoke, so purely you have to tell them firstly, I will make sure the clauses are favorable to my employer. In the same time, it will not contradict each other, because sometimes people change the clauses just like that, and there will be, because in FIDIC all the clauses are connected. You can see the reference of clauses 2.5 somewhere here, somewhere there, and reference of 13 somewhere here, somewhere there. So when you change, you ensure like you change the clauses for the benefit of employer. At the same time, you have to ensure the clauses you're changing will not contradict each other. Okay, then you can explain some clauses like this. I will change because I need to make sure that, I will tell you an example. Clause number in clause number 15, under termination, contractor can ask for the employer's financial facility. Then you can tell them, I will change that clause, I will delete the clauses completely. Then you can tell employer claim clause, I will change like this, I will change notice of delay like this. Then I will change this time for submission of what do you call that, program. All those things you can change. I would say something, you will refer to your contract and be mindful about that, which of course you can change. Okay, then there is a contra proferentem. It's a doctrine, actually. It's a legal doctrine, contra proferentem. I don't know how many of you come across this. Mainly this is, by definition, it defines that any ambiguity in a contract document is least favorable to the person who drafted it. Okay, so if there is a materialistic change or major mistakes in a contract document, be it a specification, be it a drawing, be it any other document, if there is a materialistic change or a mistake in the contract or contract document, that will not be favorable to the party who prepared that. Imagine, for example, if some mistake in the contract document and that cause a hiccups in the project, and an employer told contractor that the mistake should be foreseeable by the contractor, because your experience, that's the common word employer will use, being an experienced contractor, you should be able to foresee those and tell us. Contractually, they will use this command to block them. But when you go to legal, then legal team will, or if you go to litigation, they will see this mistake in other way. They will ask you, who drafts this contract, who prepares specification? Then employer. Then he is responsible. You write something and give it to somebody, then how can you expect somebody to take responsibility? It's completely wrong. You write an exam, okay, you write a wrong letter, you write a wrong answer, and you expect teacher to correct that. It's not like that. So that's the quota preferred law. So when you write something, you make a mistake, you are responsible for that. You don't expect somebody else to read and review and tell you like that it is wrong. So that is the essence of contra preferendum rule. Now the next question or concept, elements of contract. Guys, I have explained this elements of contract in detail about 1 hour session in my previous video, so you can refer to that. It's better, because rather than explaining over here, I detailedly explain one by one over there. Again, elements of contract is like offer is there, acceptance is there, consideration is there, then possibility of performance, capacity of party, certainty of terms, legality. These are the main elements of contract. But again, guys, go through my previous session, everything is over there. Now the privity of contract, I don't know, such a beautiful term is that, privity of contract. Privity of contract is basically preventing a third party to sue the contract. Okay, if I'm a contractor, I'm signing a contract with employer, only two party in the contract. Maybe sometimes if JV is there, the JV. Okay, so I'm signing a contract with the employer, and if I'm a contractor, I'm signing the contract with employer. So only who can sue me is the employer. So only employer will get sued is by the contractor. No third party, no any other third party is authorized or supposed to sue the contract. This is called privity of contract. The beauty is that the contract is there, that's between the contract and employer. So that is their world. A third party means anybody, anyone other than the party who signed the contract is called third party. Why this Privity become very beautiful. I am a contractor and you are an employer. We are signing the contract. We are obligated to perform the work. We are responsible. We taking responsibility. We taking obligation. We taking the risk, everything. That is both employer and contractor. In that case, why somebody else come and comment in the contract or somebody else come and sue the contract? That is the privity of the contract. So basically, even though this contract is prepared in somebody X benefit, in that case also they cannot sue. I will give you a small example. Imagine the marriage between a husband and wife. So I married my wife and I'll have kids also. Obviously, the benefit of marriage is that it's kids actually. Kids getting benefit of marriage, and we living for them, and we saving for them, we giving education for them. So benefit is getting by kids. Even though if there is an issue, nobody can comment on us. If the marriage, it is a contract between me and wife, any issue, any problem, any love or hate, that should be resolved or suffered by me and my wife, not like somebody else, a third party, my father, her mother, her brother, my kids. Nobody should comment and advise or comment on it. Okay. Similarly, let's imagine you are a subcontractor, you are having a contract with the main contractor, but this contract is for the benefit of employer because he is the one who funding, he is the one who pay. So by privity of contract, even the contract is for his benefit, he cannot sue. Keep in mind, he is the one who funding it, he is the one who owner of the project, but still he can't sue a contractor or subcontractor because the contract is between subcontractor and the contractor. So that is the wrong thing, right? If I'm funding, I'm constructing, then somebody telling no, you can't sue the contract. This is I have contract between the main contractor. You are BA employer. I don't care. That's not the right thing, right? See, guys, I'm paying money for him. I own the project, and then he's telling I'm not relating to you. I'm related only to main contractor. So to cover these issues, we have two beautiful terms called collateral warranty and third party rights. Okay. So collateral warranty and third party rights are introduced to give some benefit to third party. In our previous example, a contract between an employer and in contract between a subcontractor and the main contractor. Even though the poor employer is funding the project, he cannot sue. So to cover these issues, we have introduced collateral warranty and third party rights. Collateral warranty is a tri-party agreement actually, which is over and above the contract. Okay. So in collateral warranty, it's a separate contract. You can go to separate warranty in which you will have three parties: employer, contractor, and MEP subcontractor. So this is the contract between these three parties in which obligation and assignments are listing. They will be, they will write the they will mention the rights of an employer on this contract, and when he can sue, when he can terminate, and when he can step in. All those things will be mentioned. So this collateral warranty give a right to the employer or a third party to enter into contract and comment. Okay, but still it is by the agreement of all three parties. Collateral warranty is a tri-party agreement. MEP contractor or subcontractor is okay with that, main contract is okay with that, employer is okay with that. Okay. So this is a contract, a warranty over and above the contract. But what is third party rights? Third party rights is a provision within the contract. Okay. So let me give a simple example. You can see in the contract, in the FIDIC form of contract, the instruction can be given only by engineers. Okay. Or FIDIC mainly if it's a MEP subcontract agreement, it might have mentioned like no, instruction can be given by only by the main contractor, because in subcontract agreement they will mention contractor as this, subcontractor as this, employer as this, engineer as this. But if you want to change that, because now you cannot, as an employer or engineer, you cannot give any instruction. So if you want to add some provision in the contract, you have to define in the contract first your name. Okay, in the definition section you mention employer. Employer is like this company. When you write employer, make it capital E capital employer. Employer is this entity. Okay, now engineer is this entity, be WSP, ACOM, whoever. Main contractor, this entity, Alnabuda, Trojan or someone. Subcontractor is MEP contract, Alamco, Speakon, anyone. So when you go to that next clause, then you can mention the instruction can be given by employer on this condition. Instruction can be given by engineer in this condition. So you are adding some provision into the contract so that the privity of contract can lightly be waived off. Okay, even though privity exists in the contract, you adding a third parties into the contract and you define them in the contract, and now you adding some provisions also. This is called third party rights, guys. So that's it. I hope that's clear. The concept is clear with you. So now we have some other points from the contract practice: tort claim and contract claim. So any claims within the contract is called contract claim. Okay, it's very simple as it. Be it EOD claim, be it a deception claim, be it a variation claim, be it a exclusion claim, any claim within the premises or within the boundary of a contract is a contract claim. But tort claim is something separate. Okay, so tort is basically defined as a civil wrong which cause harm to a party, and whoever caused the harm is liable for that. Okay, so I'm driving my car. Okay, when I'm driving my car, I hit a person. It's not purposely. Okay, it's an accident. So when you're driving the car, there is a chance like you hit somebody. Could be your mistake, could be his mistake also. This is a civil wrong because of this mistake the other party suffer a loss or damage and I am liable for that. This is a very simple example for tort claim. Okay, so tort is a civil wrong which cause a loss or damage to other party, and whoever caused loss is liable for that. Okay, tort is again classified into different types actually: intentional tort, negligent tort, strict liability tort, absolute liability tort. As a part of RICS, you don't need to go deep into these details because it's more legal actually, whichever I explained. Just giving you some heads up. It's a intentional tort means you're doing that civil wrong intentionally. Okay, let me give you an example. And again, that's not a criminal offense. Okay, it's a civil offense. You are threatening somebody. You are telling somebody, if you didn't give me 100 rupees, I gonna hit you. But you haven't hit him. Okay, you didn't hit him. You're telling me only. You're telling like, if you didn't give me 100 rupees, I'm going to hit you. So it's a threatening. This is intentional threat or intentional thought. And sometimes you will speak bad about somebody else. Imagine, I'm talking bad about my cousin. My cousin is a drunkard. He used to go drunk and he going to make nuisance. This is also a tort actually. If you go to court, it's called defamation. And sometimes you will block somebody's rights to travel. Imagine your son is going out of your room and you're stopping him. He's a major 18 years old and you're stopping him, don't go. Or there is a way in front of your home and you barricading it and stopping somebody's provision to travel. This is also in thought, which is intentional thought. There is something called negligent thought, which it's not intentional, beyond control, it's happening. Because just like which I explained previously, when I'm traveling or when I'm riding my car, I'm hitting somebody unintentionally. Okay, there's something called absolute liability tort, which is mainly applicable for hazardous, somebody dealing with hazardous material like chemicals and all, chemical factories. So even though they take all responsibility and all reasonable steps, if anything happen, they're completely and absolutely responsible for the act. This is called absolute liability tort, same as strict liability tort. Okay, that's something about tort. So if somebody asks you some question about the tort, you should be able to answer it, because now you know the concept. The concept you just reproduce over here. There is some term called contract under hand and under seal. So guys, whenever you sign a contract, please ensure it's signed and stamped. Why? Under hand means only signed under hand. It's not sealed or there is no stamp. Under seal means it's signed and stamped. So when you under hand, it has hardly 6 years benefit. Under seal, it has 12 years benefit. Okay. It's all very simple level 1 question. You don't need to go deep into it actually, but make sure guys, in practical, when you sign the contract, make sure you stamp it and sign it. Okay. Now, advisor and non-adversarial form of contract. From the word itself, you can understand what is this. So any form of contract that will potentially create an adversarial relationship between the parties. That's the adversarial form of contract. Because sometimes people drastically change the general conditions. They will use FIDIC as general conditions. Still, in particular condition, when you go to particular condition, they will change everything which is not in a favor of contractor or completely biased towards employer. These kind of forms will create some issues for sure. This is called adversarial form of contract. Because guys, we can change the conditions, but make sure it should not be adversarial, because that ultimately affect your project and progress, and it's unwantedly welcoming some legal issues. So this is called no adversarial form of contract, and no adversarial form of contract obviously, which is balanced form of contract, which is not an inclined one or biased one. And next one is insurance types. Guys, it's almost the insurance, cross liability and subrogation and other clauses I will take in next session. Thank you very much for today.